There we go. Okay. How are
Hi,
you?
I'm great. How are you doing?
Okay, Allison. Good to meet you.
Nice to meet you. So, we're talking about, is it safe to say we're talking about mitigating risk?
Yeah, that's a pretty good way to put it.
All right.
How to avoid lawsuits, how to avoid licensing board complaints, and behavioral health. That's
Love
sort
all
of
that.
bottom line. Yeah, I mean protecting clients first and foremost, but yeah.
Uh-huh. Awesome. Well, I'll do a little pause. Is there anything you specifically want me to ask or specifically don't want me to ask before we get started?
Nah, go for it. Whatever.
All right. And it's Dr. Frederic Reamer, right?
Correct. Yep.
All righty. We'll do a little pause and then I'll dive in. Welcome back to the Abundant Practice Podcast. I'm your host, Allison Pereira, founder of Abundance Practice Building. Today, I'm here with Dr. Frederic Reamer. We are going to be talking about how to protect our clients, not get sued, and make sure that we're on the up and up ethically. So thank you so much for being here and talking with us about this.
It's my pleasure. Thanks for having me.
Yeah. So where should we start? What do you see as almost the most urgent thing you want to communicate?
Well, two things. One is, I think, behavioral health practitioners, whether they're licensed mental health counselors, psychologists, psychiatrists, social workers, substance use disorder specialists, they should be aware of the major risk areas. So if you look at the data on licensing board complaints and lawsuits, not a pleasant subject. Let's get that out there up front, not a pleasant subject. The biggest risks, in my experience, having been an expert witness in this arena for many, many years, the biggest risks have to do with management of complex boundary issues, dual relationship issues, decisions about disclosure of confidential information when you don't have clients' authorization to protect third parties, or maybe there's a law enforcement inquiry, or you're providing services to a minor and the parents want to know what's going on in therapy. They want to see your notes. Issues around informed consent, issues around conflicts of interest, termination of services with a client who's missed a number of appointments or is not compliant. And most recently, challenges related to the use of technology. When I started my career, these issues didn't exist. When I started my career, a tweet was the sound a bird made, not something associated with a smartphone app that
Mhm.
used to be called Twitter, now called X. And when I started my career, and I suspect this is true for many people who are viewing this,
Mhm.
TikTok was simply the sound a clock made, not a smartphone app. And the cloud is was the white fluffy thing in the sky, not where you store your electronic records. And so more and more I am seeing litigation cases and licensing board cases where there are some very serious and complex questions about how practitioners are using technology to serve clients remotely, to communicate with them outside of normal working hours using text or email. Practitioners who are friending clients or former clients on Facebook or Instagram, let's say. The ways in which we store information in the cloud. And I could go on and on and on about the ways in which the cloud storage has created some ethics problems. So that's one thing, just knowing the risk areas. And the other thing is that I think practitioners should be intimately familiar with practical steps they can take to, number one, protect clients. I think we would all agree that's our first priority, protecting
Mhm.
clients, but also practical steps that practitioners can take to protect themselves, to minimize the risk of a lawsuit, to minimize the risk of a licensing board complaint. And then if one of those things seems to be in the offing, steps they can take to try to reduce what lawyers call their exposure.
Mhm. These are all really juicy. I feel
A
like
lot of
we could
juice, a
probably
lot of
do
juice.
like hours on each of them. Um, can we start some in talking through the problems you see arise most? I think the first thing you mentioned was dual relationships.
Hmm.
Can we start to talk about how that exists? And I know technology makes it, for some reason, my Zoom is making uh graffiti, not graffiti, whatever that was, confetti. Um,
Hmm.
Ken, speaking of technology, it's like you're
Hey,
talking about me.
I think that was well-timed confetti. Clearly we needed visual effects for this compelling conversation.
Amazing.
Hey,
Um,
technology. What are you going to do?
I know. It's it's ruling us right
Not
this
a problem.
second. So what are you seeing particularly in the relationships realm when you're an expert witness or working with people?
So, with regard to that specific topic, the dual relationship boundary issues, so many of the lawsuits that I have to consult on and testify in, if they get to trial, so many of the licensing board complaints involve those issues. Everything from the egregious sexual involvement with a client or former client, as in they terminated 10 minutes ago and then entered into the intimate relationship. So
Mhm.
those are the egregious cases. But then there are more complex cases where, and I've seen a number of these, where practitioners are quite altruistic. They are very concerned about a particular client who's vulnerable. They start to perform some favors for that client. In one case, the client was physically disabled. The practitioner was doing some food shopping, giving the client rides, taking the client to appointments. And this is psychotherapy. I mean,
Mhm.
that was the nature of the relationship. And surprise, surprise, the client became very dependent on the practitioner. I think began to have some fantasies that this was going to turn into a more intimate relationship. The practitioner realized it, started to set limits, and the client didn't like that and filed the board complaint. I've
Mhm.
seen a number of those kinds of cases where well meaning, that's the point, well meaning practitioners, not the practitioners who are trying to seduce a client or engage them in a sexual relationship. That's a different category. And I've had, sadly, a number of those cases.
Mhm.
Um, but well meaning practitioners who put their foot on the slippery slope and they end up performing too many favors. They're disclosing too much personal information to clients. The boundaries become very fuzzy. And then the client doesn't like it when the practitioner sets limits and it ruptures the relationship. And here comes the licensing board complaint. So I want to distinguish between, and this is the jargon we use in the field, so-called boundary violations, the more outrageous, inappropriate relationships, and those that are sort of in the gray zone, what those of us in the ethics trade call boundary crossings.
Mhm. And so I personally function from if it feels not very clearly okay, then I veer no. Is that a fair way to do it? Are there other ways to mitigate your risk when it comes to your relationship with clients and like managing? I'm thinking about people in small towns who may go to
Mhm,
church with their
mhm,
clients, or
mhm,
their kid's teacher is their client or something like
mhm,
that. It's
mhm,
easier where
mhm.
I live, it's not as small. Um,
Right.
but how do you help people discern whether or not that they're putting their foot on that slippery slope?
Well, great question. And I would say, yes, absolutely. Trust your sort of internal radar. If it, if your meter sort of goes off like, nah, this one doesn't feel quite right, trust your gut. But I would say that's a necessary but not sufficient
Mhm.
element or variable in the equation. I would say there are some other key variables in that equation. So I'm a big proponent of consultation. If, for
Mhm.
example, you are living and working in a small town, and as you suggest, your personal life is going to intersect with your professional life and your work with clients at church, in the supermarket. You have a 9-year-old child who's in the third grade, and your client has a 9-year-old child in the same third grade. There's only one third grade in this small town, and now those kids, surprise, surprise, are best friends forever, so they think, and they would
Mhm.
have planned a weekend sleepover at your house. Well, can you do that? Can you have your client's kid sleep over at your house? You're the therapist. And so, or let's say you're a clinician in recovery and you go to a 12-step meeting and there's your client. You've got to
Mhm.
make a decision about whether to stay, whether to leave. If you stay, do you share? If your client gives you an expensive gift and you have to decide whether to keep it, so as not to insult your client, or whether to say, gee, I'm so sorry, I can't. And then you have the difficult conversation, or the client invites you to the wedding or the graduation ceremony or the bar mitzvah or the baby naming. All of these circumstances, I'd say, in addition to sort of trusting your own gut or that radar, get consultation. I would say one of the biggest mistakes practitioners make is they're solo pilots. They handle these
Mhm.
things on their own. And I recognize that most practitioners are very competent and very smart, and they exercise good judgment most of the time. But sometimes we're so close to these complicated situations that it behooves us, I think, to get consultation from thoughtful colleagues, from supervisors if you work in an agency, if you're in private practice. I think you ought to be part of a peer consultation group and run it by colleagues to try to get some more objective view of the situation that you're very close to. In addition, another variable in the equation, if I can use that metaphor, in addition to trusting that kind of internal radar that you mentioned, in addition to consultation, be familiar with the ethics standards in your profession. And they are not all the same. So I chaired the national task force that wrote the code of ethics for the social work profession. Now, most of the ethics guidelines, when you compare social work with psychology, with psychiatry, mental health counseling, marriage and family therapy, and so forth, they're pretty similar in most respects, but there are some key differences. And I get involved in cases where the practitioner is on witness stand and a prosecuting attorney or a plaintiff's attorney asks them to describe the current ethical standards in their field related to the case, and they blow it. That they don't know what their current code says. For example, with regard to relationships with former clients.
Mhm.
And if you line up the social work code of ethics with mental health counseling code of ethics, by the way, there are three of those in mental health counseling. That's a different story. The psychology code, the MFT code, et cetera. The standards on relationships with former clients are very, very different. And
Mhm.
people need to know that. Um, one profession says can't have a relationship with a former client within 2 years of termination. Not that they would encourage it, but you can't do it within 2 years.
Mhm.
Another code says 5 years. The social work code, written by the task force that I chaired, says basically once a client
Right.
in perpetuity. There's some very narrow exceptions, but very narrow. And so that's another variable in the equation.
Mhm.
Another variable in that complex equation is know the ethics standards adopted by your licensing board. Some licensing boards in their statutes, in their regulations, actually cite a professional code of ethics from psychology, social work, counseling, and so forth. But not all boards do that. Some boards create their own ethics standards, which might be different from the standards in your code of ethics adopted by your profession. You're held to those. You got to know those things. And
Mhm.
finally, I would say know when to consult an attorney. I don't think you need to consult an attorney every time there's an ethics challenge. I think that's
Mhm.
frankly kind of silly. If your client happens to bring you a plate of chocolate chip cookies with nuts and says, "Oh, I made some extra. These are for you." What are you going to say? Hold on. Let me call my attorney to find out if I can accept these. That's a judgment call. Let's not be silly here. If a client asks you, I've been kind of wondering, how old are you? Where do you live? Do you have any kids? A lot of clients ask those questions.
Mhm.
What are you going to say? Time out. Let me call my attorney. No, that's a judgment call, both clinical and ethics. But
Mhm.
there are a lot of ethical issues with which I deal where I think you have to get legal consultation because some of these issues are really, really complicated, involving very esoteric confidentiality provisions. There's federal law, there's state law. The federal law may conflict with the state law. I'll give you one quick example. I was involved in a case where an adolescent was brought in for counseling. Parents brought the kid in. The parents knew the kid was getting counseling. The kid was struggling with mood issues. And then it comes out in the counseling, air quotes, confidentially. By the way, I use air quotes because to me, the term confidential case record is complete fiction. There is no such thing. I
Hmm.
can rattle off 24 different ways in which records are not confidential, but that's a sidebar. So this kid during counseling discloses confidentially, air quotes, to the clinician that he's struggling with substances big time and he wants help. And this is at a mental health center where there is a program that is designed for high risk adolescents with co occurring issues, mood disorder, substances. Federal funding, don't need the parent's insurance card. Clinician says, I can get you help. We have a program right down the hall. Um, but I want to tell your parents what we're doing here. And the kid says, absolutely not. The kid does not consent to that because he thinks the parents are going to, air quotes, kill him if they find out about the substance use. Not literally, but give him a hard
Mhm.
time. And so, despite the clinician's skillful efforts, the kid does not consent to the disclosure. And then the question is ethically, can you arrange services for an adolescent without telling the parents that you did it, the substance use counseling? There's external funding. You don't need the insurance card, so they're not going to find out for that reason with the EOB. And this is really complicated because there's federal law that's relevant to that decision, Title 42 CFR Part 2, Section 2.14. Literally, that's where it is. And then there's state law, and the state laws on this issue differ dramatically with regard to provision of substance use disorder counseling services to minors without notification of parents. Some states permit it, some states don't. Those that do permit it, it might depend on the kid's age or whether physicians sign off on this. It is complicated and it's high risk. And if you provide services to a kid and without the parent's knowledge or consent, and then they find out, which often they do, and they file a lawsuit or a board complaint, that's a problem. And that's an instance where consulting with a lawyer, that's the main point here, I think would be extremely smart. So
Mhm.
knowing when to consult with a lawyer, when it's not necessary, that's another variable in the equation.
Yeah. So I get asked questions from my students or people in my audience all the time that are ethical in nature, and I am not well versed enough. I don't want to step in that.
Mhm.
So I often will recommend that they call their malpractice insurance, and they usually will have a free call with an attorney through there. Is that good advice? Is there somewhere else I should be sending them?
So I think it is another tool in the toolbox.
Mhm.
However, I wouldn't rely on that for legal advice entirely.
Mhm.
Why? If the insurer links you with an attorney, who is that attorney's client? Is it you
Mhm.
or are they there on behalf of the insurance company? So if it's a complex case, first of all, I would get that consult. That's good information. But I always prefer to consult an attorney. If it's a complex legal case, I always prefer to consult an attorney who's going to represent me, not an insurance company. And the way to do that is um, to find an attorney where you live and work who specializes in number one, healthcare law. That's number one,
Mhm.
not labor law, not criminal law, not your sister in law, who's a terrific labor lawyer who will do it for free. She doesn't know this area of the law, with all due respect. If you have knee pain, are you going to go see a dermatologist? The dermatologist went to medical school. I would think you'd want an orthopedist, not a dermatologist. Same thing with lawyers. So, number one, I want a lawyer who specializes in healthcare law. And then within that, I want a lawyer who specializes in representing behavioral health professionals in litigation and licensing board cases, not a plaintiff's attorney. That's another key
Mhm.
distinction. I don't want a plaintiff's attorney. I want a defense attorney because defense attorneys get up in the morning and spend all day long thinking about how to protect people like us. Um, if your audience members belong to a professional association, American Psychological Association, National Association of Social Workers, American Counseling Association, and so forth, they may be able to get some ethics consultation through that association. Typically, they cannot tell you what to do. They cannot advise you. You should do X, don't do Y. Legally, they may not be able to do that, but they can walk you through the situation and help you kind of identify what the ethical issues are, what your options are. And even though they can't tell you what to do, here is a major, major benefit of making that phone call, whether it's consulting with the ethics office at the National Association of Fill in the Blank, psychology, social work, whatever, um, consulting with an attorney. I get a lot of calls because I specialize in ethics. I get lots of calls for consultation. Here's the advantage of that. In addition to getting the substantive consultation, which I hope is helpful, just the fact, just the fact that you reached out for consultation, which, by the way, please
Hmm.
document that you made that phone call. If your judgment is ever questioned down the road in a lawsuit, in a board complaint, you have to defend your decision around the boundary issue, around the confidentiality issue, or around the termination of service issue, whatever it happens to be. The fact that you sought consultation adds a layer of protection. A lot of people, I think, don't realize that. In
Hmm.
addition to the substance of those conversations, just the fact that you did it shows that you made a good faith effort to handle the situation responsibly. If you consult the code of ethics, document that you did it. Consulted a National Association of Social Workers Code of Ethics Standard 1.09C or 1.06D or whatever standard is relevant, put it in your notes to demonstrate the good faith effort. If you consult the ethics guidelines adopted by your licensing board, document it. If you consult your members of your peer consultation group, document it.
Hmm.
Those notes are worth their weight in gold if there's a
Hmm.
dispute.
And I would assume it also helps if the consultant also has kept notes, has documented that conversation.
Well, that's a little tricky. So, there are, in my experience, two ways to get consultation from colleagues.
Hmm.
One is from a supervisor. Now, if you're in private practice, typically you don't have a supervisor. But if you work at a mental health center or a substance use disorder treatment program, typically you have a supervisor. Supervisors, I advise, should always keep notes, supervision notes.
Hmm.
But if you are a member of a peer consultation group, I've never encountered a member of a peer consultation group who documents the conversation.
Hmm.
When I get calls, so, I do lots of ethics consultation. I don't keep notes. I don't get paid for that consultation. I don't work for anybody. I'm just trying to help out, you know.
Hmm.
I don't keep notes. And as a consultant on a case, I'm not expected to keep notes. A supervisor
Okay.
is a kind of consultant. So supervision is vertical, right?
Hmm.
Notes are expected. Peer consultation is horizontal. The person getting the consultation, I think, should absolutely document it. But the person who's providing advice or feedback, there's no expectation that they should. Geez, if I documented every phone call I get during a typical week, my hand would hurt. I'd be writing so
Hmm.
much or typing, And I don't do it. I don't. There are some occasional instances where it's a very high risk situation. I think I might end up being dragged into it as a witness,
Hmm.
and then I'll keep notes, but that's very rare, very
Hmm.
rare.
Okay. So I'm hearing you think you may be something might be on the line. It makes sense to call an attorney. Maybe start with your malpractice insurance, the free phone call, but maybe don't settle there. Um, to be really clear about what your code of ethics says, as well as
Mhm,
what your state licensure requires of you.
mhm,
Um,
mhm,
to let's see, to consult with peers and or a professional consultant or
mhm,
supervisor, depending on your
mhm,
circumstance. What are
mhm,
some other things we can do to make sure we're taking care of
mhm.
ourselves and our clients?
Great question. Okay, so I would add a few other things very quickly. One is if actually, let me make a statement before I add those things. People listening to this might be thinking, oh my goodness, I'm likely to get sued in my career. I'm likely to have a board complaint filed against me. Here's the good news. The vast majority of behavioral health practitioners will retire without ever having been sued,
Mhm.
without ever having been named in a board complaint. That said, this is what I spend a lot of my time on. There are lots of cases out there. But don't want people to feel like there's a lawsuit or a board complaint hiding behind every bush. It's not true.
Right, right.
Okay.
I
We want to
appreciate you saying
minimize,
that
yeah,
because
yeah. We
sometimes when
want to
we talk
prevent
about
problems.
ethics, it feels very scary.
Yeah, yeah.
So,
And most things in life I don't know anything about, but I know the statistics on this. And we are pretty good risks in behavioral health. But there are a lot of cases out there, and I want to prevent problems. Okay, but back to the question. Um, Practice standards. So what does that term mean? In litigation and in board complaints, if there's a hearing or a trial, practice standards in your particular behavioral health profession are likely to be introduced as evidence. For example, and those are different from codes of ethics. So, for example, several years ago, I was invited to chair another national task force sponsored by several behavioral health organizations to develop state of the art guidelines for use of technology, ethics informed practice standards regarding delivery of remote services, communicating with clients on online social networking sites, doing online searches for information about clients without their knowledge or consent, all kinds of stuff. And it took the task force that I chaired a year and a half, and we produced and we tried to keep it short, and we flunked because it's not short. It's 61 pages long,
mhm,
61 pages of practice standards, ethics informed use of technology. So, another piece of advice is know the practice standards in your profession related to these kinds of issues. And those go beyond what's in a code of ethics. Practice standards are usually developed by task forces appointed by the American Counseling Association, Marriage and Family Therapy, American Psychological Association, NASW, et cetera, et cetera. Okay, one more thing. When I go into a courtroom as an expert witness, and that's not my term, that's the court's term,
right.
expert witness. I absolutely expect that attorneys on both sides of the case will have done a comprehensive literature search regarding whatever issue is in dispute: confidentiality exceptions, boundary issues, dual relationships, termination of services. Why do they do a literature search? For reputable books, reputable book chapters, reputable professional journal articles, not self published stuff. They don't care about that.
Mhm,
The reason they do that search is if they find reputable literature that supports their theory in the case, they will introduce it as evidence. It becomes exhibit 13 for the plaintiff or exhibit 24 for the defense. It literally goes on the record as evidence of what we call the standard of care. And that's the league term. Standard of care is the measuring rod. Every lawsuit I get involved in, and I've been involved in a lot of them, fortunately not as a party, but
right.
simply as an expert witness. Every single time I get involved in a lawsuit as an expert witness, I'm asked to review the clinical notes, the progress notes, the psychotherapy notes. Those are not synonyms, by the way.
Mhm,
Those are different things. I'm asked to review correspondence. More and more, I'm asked to review what's called ESI, electronically stored information. Every text message, every email message, it's all fair game. And sometimes I'm asked to interview the practitioner as part of my expert witness work. And then the attorneys will always ask me, so, Dr. Reamer, now that you've had an opportunity to review all of the evidence and the documents, and you've interviewed my client, the practitioner, in your professional opinion, did the practitioner meet the standard of care in social work, for example, or fall below it? That phrase, 3 words, standard of care, is the measuring rod. And it is defined very precisely by attorneys. It all started in the late 1800s, no kidding. A very famous court case that originated in the state of Maine that went to the Maine Supreme Court called Coombs versus Bede. And that case introduced this concept of standard of care, which today is as relevant to behavioral health as it was to the field of the law, the profession of the law in the late 1800s. Every single case, that's
mhm.
the measuring rod. So, literature, in addition to codes of ethics, in addition to practice standards, literature is part of the standard of care. So, I recognize that, the typical practitioner in a hot ethics crisis isn't going to say, time out. let me run over to the library and see what the literature says. I mean, who does that, right?
The ones that
Um,
intellectualize will do that.
yeah. Or it's not an emergency,
Uh-huh.
But the typical practitioner is not going to do that.
Right.
But I would say it's important to know that that literature, whatever's relevant, could end up being introduced as the measuring rod against which to assess what you did. And if you are not in a position to run to the library physically or now typically electronically, find somebody who knows the literature.
Hmm.
Get the consultant, the colleague who's like really familiar with literature on boundaries and dual relationships and consult that person.
Yes.
Um,
Like you, right?
well, yeah, I suppose. And,
Mhm.
people who do what I do. The other thing I want to mention in answer to your question is actually two things. One is please maximize insurance coverage.
Mhm.
Maximize insurance coverage. I get it. Most people don't want to read insurance policies. They kind of click the boxes, pay the premium, and move on. And I encounter clinicians who don't know what kind of coverage they have. They have a licensing board complaint filed against them. I say, well, how much coverage do you have? I have $1 million. Nope, you don't. There's no such thing as $1 million worth of coverage for a licensing board complaint. That's for a lawsuit.
Mm.
Figures like a million, that's lawsuit. But there's separate coverage for legal defense and licensing board cases. And that's usually a figure like 30,000, 50,000, 60, whatever. And there are different tiers, different premiums. I tell people, please maximize your coverage. And if you are dealing with technology, if you're providing services remotely, you're storing information in the cloud, there are all kinds of risks with regard to HIPAA breaches and databases that get hacked. I now encourage people to take out what's called cyber liability coverage as part of their policy.
Mhm.
CYBER, not PSY, but
Mhm.
CYBER liability coverage. It's not that expensive, but there are lots of cases out there now where there's been a technology breach.
Mhm.
And the one other practical tip I'm going to throw in here is if, heaven forbid, you're named in a licensing board complaint, we've all had clients who become angry with us for one reason or another. All you need is one to file the board complaint, which is, by the way, easy to do, costs them nothing. They don't need a lawyer. They just go to the website, find your name in the licensing board roster, and they click file a complaint, and then they free type. And then you get a letter saying you have 21 days to respond or whatever it is in your state. Here's the biggest mistake by far I see with regard to licensing board complaints. And that is that clinicians are upset, understandably. I didn't do it. That's not what happened. And then they respond on their own.
Mm.
Horrible mistake, typically. And I don't mean to insult anybody's intelligence.
But it's a
I
world
often
we
get
don't
the
know about as clinicians,
exactly,
right? Like we need
exactly.
a guide for that.
And there are, as I said before, there are lawyers. This is what they do.
Mhm.
And the experienced lawyers, not the one who handles the auto accident in the morning and criminal defense in the afternoon and squeezes you in for a licensing work. I don't want that attorney. With all
Mhm.
due respect, I do not want that attorney. I want the attorney who does this stuff all day long. And that attorney, number one, knows how to craft a response where every word is carefully chosen and they know
Mhm.
what to say, they know what to cite in terms of ethics standards and statutes and regulatory language and what footnotes to put in there. And they also know what not to say. And that is as important. And so, too often, I get involved after the clinician has written the response on his, her, or their own. They didn't consult an attorney. I read it and I was like, I wouldn't have said that. And then I say, I think you really need to consult an attorney. And then they do. And the attorney looks at it and goes, you know what? We're going to have to file a supplemental response because this one's got some problems. Please don't be insulted. But once you send that thing in, you can't delete it.
Right. They
You've
can't
rung the bell.
unsee
You
it.
can't.
Mhm.
It's there. All you can do is try to
Mhm.
clean up the bit of a mess.
Right.
Um, I did think of just one other thing, and that is I imagine many people listening to this are in private practice and have their own malpractice coverage. Great. But some people listening to this may work for the hospital, psych hospital. They may work for a substance use disorder treatment program, a school district, whatever. And some of them do not have their own malpractice coverage.
Mhm.
They rely on their employer's policy. I cannot say this more emphatically. Please don't do that. There, I could take an hour and explain why I think it's just a bad idea to rely on your employer's coverage. There could be a conflict of interest. There could be a judgment that exceeds the value of their coverage. You may not work there forever. That could create a problem. You want your own policy.
Mhm. Absolutely. Oh, thank you so much. This is very helpful. I'm looking forward to the training you're going to do and the abundance party where we get to dig in a little bit more. And yeah, thanks so much for being here.